All right, I see Mr. Drake. Good morning, sir. And I see Mr. Steinberg. Good morning, sir. All right, we're ready to proceed. And Mr. Drake, as you know, you are given 20 minutes. How much time would you like for rebuttal, sir?
I'd like to reserve 5 minutes if I might.
Very good, sir. And whenever you're ready, Mr. Drake, we are ready.
Very good. May it please the court, I represent Henderson Franklin and William Boltrick, a member of that firm. We recognize the burden to establish grounds to disqualify opposing counsel. It should take a unique case, and this is a unique case. It's one of a new type of claim in an effort to collect a consent judgment from an underlying auto accident in excess of available insurance policy. A legal malpractice case has been brought against the defense counsel for negligently failing to settle pre-suit as an adjunct to a bad faith case against the underlying defense insurer. So how does a judgment creditor, in this case the Schmitz is the underlying plaintiff, do that without privity? Because Florida law does not permit.
Mr. Drake, let me stop
Yes.
you. I mean, they figured out a way to do it. And I
Yeah,
think that is your, really, the axe you have to grind in this case is that this is a veiled assignment and you don't like it and you don't think it's appropriate. And, but that doesn't mean that counsel gets disqualified. Because I've been reading through the record. I mean, that's a recurring theme in the arguments that you have made is this is a veiled assignment. They shouldn't be able to do this. And that's one issue. And maybe if there's a problem with that, or if you think there's an ethical issue, you can take it to the bar. But, you know, they have figured it out. They've done it. And now you want to disqualify their counsel.
well,
So
yes, Your
there are
Honor.
certain obstacles to overcome to be able to do that.
You're right, there's obstacles to overcome. You're right that we have an underlying, a thematic defense that you can't jump the privity bar by creating a vehicle like a receivership to do what they've done. But they've added an enhancement to that, which is they take the actual plaintiff's counsel who represented the plaintiff in the underlying case, and they've used that plaintiff's counsel to now represent the receiver. Now, it's not, you know, I've had it said to me that, well, in bad faith cases, insurers, bad faith defense counsel say, bad faith case happens all the time. This isn't a bad faith case. What this is a legal malpractice case. And what we've got is the plaintiff's counsel who is actually involved in the conduct, the other side of the conduct of the negotiations. They say my client mishandled, causing the failure of the negotiations, who chose the receiver. Remember, Mr. Noon, the co-counsel, said that they chose the receiver, that they met with the receiver, and they've taken that, and now they represent, in essence, my people's, my clients' former clients, in an effort to really collect damages against the defense counsel for their underlying injuries.
Well,
And I think that
I
creates a
think
different
here's-
environment,
Let me
Your
just
Honor.
distill this down, because here's your biggest fear. Is they're going to get a hold of your file or Mr. Boltrick's file. That hasn't occurred yet.
Well, it has, Judge.
Swopes, how in the world did that happen? How did the judge let that happen, and how did you not object? So, but let me get to my point first of all. Swope is co-counsel, and you know about it in 2017, but you certainly know about it in 2020. For whatever reason, you wait 19 months to DQ him. But what Swope knows about Noon and all these strategies, that's what the co-counsel is supposed to know. Your concern is that JL through Mikkel is just going to share the file without you knowing it. I don't see that in the record. It's a valid concern, but I'm not so sure that a DQ is the vehicle.
Well, so as far as the sharing of the file, we've litigated that to a certain extent. The court, the magistrate, and then the judge, as a result of that, ordered production of certain portions of the file which have been produced. Certain portions, a minority of the portions of our
Well,
file.
I mean, but you have a remedy via of assert if, obviously, if it's cat out of the bag. I don't know if you've done that, this,
Well,
there's a
part of-
remedy.
Part of the file was produced by the insurance counsel, the insurance company, because as you know, in bad faith case, most things aren't privileged. So
But attorney-client privilege is still not discoverable in a bad faith.
correct, and certain documents have been withheld, and magistrate on that has claimed that those are privileged, found they're privileged, and that was before we got to this point, before that case was stayed pending resolution of the appeal. That issue was was before the trial judge for determination of whether the attorney-client privilege on those particular documents should stand. So yes, however, that's where this stands. The plaintiff, on the other hand, takes a position that their entire file is not subject to disclosure, and that they share common interest with the plaintiff. The receiver shares common interest with the Schmitzes, and so all of their files and their communications aren't subject to disclosures at all. So they're seeking and obtaining my client's files, and they're wanting to depose my client at the same time that they're taking the position with themselves that their files are privileged and that their testimony is privileged. Mr. Noon testified, asserted privilege a number of times. We filed a notice of taking deposition of the plaintiff's counsel because I think they're material witnesses, and they opposed on the grounds that they're counsel. And it's a hard burden to take deposition of somebody who's an actual counsel in the case. It's more than just taking former counsel's deposition. Now, the court says, I think you had 2 points. The first one was it was 17 months. Absolutely right. If we're writing solely on the existence of the petition, then my client knew July of 2017. Certainly my client was aware, or should have been aware, recalled when the suit was filed January 2020, that the petition was there. But that wasn't the complete basis of the factual basis for our motion. We deposed Mr. Noon, who was co-counsel, and he brought out a number of points. Let me see if I can find those so I don't miss a few of them.
Mr. Drake, Mr.
Yes,
Drake, I
ma'am.
want to interrupt you
Go ahead.
before you go further on this, because I think if I understood your argument correctly, what you got from Mr. Noon's deposition was that the Swope firm might have been involved earlier than you thought, and that he didn't know whether or not they terminated their fee contract with the plaintiff in the underlying action. Is that right?
And that plus
But your argument in your brief is that whether that's an ongoing, whether they've terminated that relationship or not, doesn't matter to your disqualification motion.
we've made that as an alternative argument, sure.
So you knew then when you got served with this malpractice case back in February of 2020, you knew everything that you needed to know, that there was a receiver. Okay, when was the receiver appointed then?
The receiver was appointed October 2019. Lawsuit was filed January 2020. According to the plaintiff's unsworn statement.
Okay, and so you knew Swope represented the receiver at that point?
When they filed the lawsuit.
Right. And you said it doesn't matter if Swope still represented the plaintiff in the underlying action or not.
Well,
As far as your disqualification motion.
the other
And I mean, I think there's some correspondence somewhere, and maybe it related to the underlying litigation that when you found out Swope was involved in representing as co-counsel the plaintiff in that case, that bad faith was coming. I mean, you guys, this was just like you were on notice who you were dealing with and what they were going to do, and that they were going to try to like set this up for bad faith, but you just didn't anticipate they were going to try to set it up for legal malpractice, is what it looks like.
the other fact that I would ask the court to consider is that Swope unlike what it says in the petition, which suggests that Swope was being retained at that time to represent the plaintiff. And at that time was 6 to 9 months after the case, after negotiations and contact with Mr. Noonan started. Mr. Noon testified that Swope's firm was involved pretty much from the get-go. And Mr. Noon testified that he was in relatively constant contact with the Swope firm throughout his representation, and that included when they were negotiating pre-suit. And that's a critical time frame, Your Honor. It wasn't just that they were involved in January of 2018 after the suit was filed, after the alleged bad faith that occurred, after the alleged negligence that my client is said to have committed by failing to settle the case. It was long before that they were involved, and they were the primary consultation or advisor of Mr. Noon. What do we, so I think we've answered, or I've filled in the questions that.
Well, I'm still not sure what, based on the argument that you've made as to it doesn't really matter if they're still representing the Schmitzes or not.
Well,
as far as your disqualification motion, what you didn't know right from the outset of the suit.
well, again, that was an alternative argument. Perhaps we shouldn't have raised the alternative argument, but lawyers always do. Our primary argument, Judge, is that they still represent the Schmitzes. And they currently represent the Schmitzes, and they currently represent the receiver. And there's no evidence that they don't currently represent the Schmitzes, none. They say, and they put it in unsworn argument, and they put it in unsworn discovery responses that their representation is terminated. Mr. Noon testified he didn't know one way or the other. Well, how's that?
It seems, I read in the record that either Mr. Steinberg or whoever was representing Mr. Swope offered to show the judge privately that Mr. Swope had terminated representation. I didn't hear a peep out of Henderson Franklin Starnes below. But secondly, let me point out something as it goes to waiver. February of 2017, Mr. Noon files a petition to confirm the fee agreement with Mr. Swope. So a fee agreement with Mr. Swope certainly implies that Mr. Swope is doing more than just fielding phone calls and offering suggestions. The fact that he reveals to you at his deposition in 2021 seems immaterial when he's filing a judicial acceptance of his fee contract in 2017. Help me out.
I'd be happy to. The petition was filed 6 to 9 months after the negotiations started. The petition, when you read it, indicates that Swope was being retained at that time. The conduct for which we've been sued are the pre-suit negotiations. Lawsuit had been filed in September. You said 2017, February 2017, regardless, the preceding September, the lawsuit was filed and the alleged bad faith and the negligence had occurred. So all of the conduct for which my client's being sued happened long before Swope was retained. Yes, we found that in the underlying case, but we didn't know when Swope was retained and what Swope's involvement was in handling the pre-suit and advising and being involved in the pre-suit negotiations, the conduct for which we're being sued, saying we did it negligently.
Well, I still recall that there's correspondence in the record where, I don't know if it's from you all or the insurance company, but it's like, hey, Swope's firm's involved. This is going to bad faith. So you knew before that petition, it seems like. I don't recall the date of that correspondence, but.
The correspondence, that correspondence exists. That correspondence is part of our.
Mr. Drake, before you respond, I want to tell you that you're about to get into your 5-minute rebuttal.
All right,
Okay?
let me answer the judge's question, and then I'll reserve the rest of my time. The correspondence exists, Your Honor. It says clearly that it seems that they're trying to develop a bad faith case. That's because they agreed to settle with the two individual defendants, but didn't want to settle with the defunct corporation and hold the case out as to them. It's there. That was part of our file, which was produced by the insurance carrier and then on order of the magistrate by us. I'll reserve the rest of my time for rebuttal.
Very good. So you have about 4 minutes, sir.
Thank you, Your Honor.
All right. Whenever you're ready, Mr. Steinberg, please proceed.
May it please the court. Brent Steinberg on behalf of the plaintiff, Gerard McHale, as receiver of JL Logistic. Your Honors, the issue before this court is whether the trial judge, Judge Gentile, abused his discretion in denying defense motion to disqualify plaintiff's counsel, my firm. And this court must affirm for 3 reasons. And the first, as has been alluded to, is that the trial court found waiver, that the defendants waived their right to seek disqualification by failing to file their motion with reasonable promptness. That is the threshold issue. We don't get to any of the other issues unless the court first finds that that was an abuse of discretion, holding, considering all the circumstances of the case, that the defendant's 19-month delay in filing the motion was not acting with reasonable promptness. The second issue, and the second reason the court should affirm, is that the trial court found no conflict. Defendants, first, the trial court found didn't have standing to complain about any alleged conflict between Mr. McHale and the Schmitzes. And then second, even if they did have standing, defendants didn't demonstrate any conflict existed. And then the third issue is that the trial court found no unfair informational advantage. That happens when a counsel learns of an opposing party's privileged attorney-client communications, meaning Henderson Franklin's communications with their own law firm that is defending them in this case. If that happened, we could be disqualified because of that knowledge, the unfair informational advantage, as the case law calls it. But it's undisputed that we've never become privy to the defendant's privileged communications with their own lawyers. So there was nothing about my representation of the Schmitzes that created an unfair informational advantage as defined in the case law. Now, in order to reverse, this court would have to find that the trial court abused discretion on 2 of those 3 issues. First, the court would have to find that the waiver was an abuse of discretion, and then that the trial court abuses discretion on either of the 2 remaining issues, either the conflict of interest or the unfair informational advantage. And without those findings, this court has to affirm. So defendants, as the court noted, has a very high burden here. And just to remind the court, disqualification of a party's counsel is an extraordinary remedy. The case law says it should only be employed in extremely limited circumstances because it impairs a party's right to employ a lawyer of their choice. And this court has repeatedly said that these motions should be viewed with skepticism, cautioning against the use of these motions for tactical purposes, which I would argue is precisely what's happening here. Now, in the trial court, the defendant had the burden to demonstrate a factual basis for disqualification with evidence, not speculation, not argument of counsel, with actual sworn testimony. And the court issued a 12-page order explaining why and how the defendants failed to meet that burden. The question for you is not whether you agree with every part of that order. The question is whether the trial court abused its discretion in denying disqualification, whether no reasonable person could reach the same conclusion as the trial court. So that is the issue before this court.
Let me just stop you for a minute, because you reminded me of something I thought was a little perplexing. You've argued that they delayed too long. They waited 19 months. They say, well, we had to get evidence. Now, and you're also faulting them for not having evidence. So if they waited the 19 months to get evidence, why is that an unreasonable delay? Because you're insisting they needed to have that evidence, and you're still not satisfied with what they have.
Well, to this day, they've not put forth any evidence demonstrating a basis for disqualification. But what they are arguing, the basis for their argument, is all stuff that they knew right when the lawsuit was filed. The whole genesis of their argument is simply the fact that my firm represented the Schmitzes during the underlying action and now represents the plaintiff. And Judge Sleet, you might recall there's a case called LEB versus DDC, that the opinion was issued almost exactly 2 years ago to the day, where you were on a panel with Judge Silberman concurring with an opinion authored by Judge Vellante. And it so happens is probably the leading authority on this waiver issue. And in LEB, this court said that a motion to disqualify must be made with reasonable promptness after the party which discovers the facts which lead to the motion. And the rationale is to prevent opposing counsel from using these motions to deprive a party of counsel of their choice after completing substantial preparation of the case. And in LEB, the court actually reversed a trial court order granting disqualification, where the movement was aware of the facts supporting the disqualification for about 14 months before filing the motion. And the court held that that was not reasonably prompt for reversing. Now, Judge Kelly, there's no bright line rule about what it means to be reasonably prompt, but the case law shows that a 9-month delay was not reasonably prompt, or has at least been held not to be. And what we have here is this 19-month delay where it's undisputed that they were aware from July of 2017 that my firm represented the Schmitzes, and undisputed that they were aware that my firm represented Mr. McHale when we filed suit in January 2020. I mean, I'm the one who signed the complaint. And that 19-month delay from January 2020 to September 2021 is what the trial court found what was not reasonably prompt. Now, it was only when we started arguing waiver that the defendants claimed that they only learned of the facts supporting their motion during the deposition of Attorney Noon, which was June of 2021. And they say that because their motion was filed within 3 months of that deposition, it was reasonably prompt. And the trial court considered that argument and it rejected it. And it found that the timing of my firm's representation of the Schmitzes and the degree of my firm's involvement in the underlying case were not relevant considerations to the arguments that the defendants were raising in their motion. And essentially, this deposition was just being used as pretext to try to explain away the 19-month delay. The trial court also noted that the defendants were already accused of my firm of a, quote, glaring conflict of interest in court filings 2 months before Mr. Noon's deposition ever occurred, supporting the idea that this was just pretext. So the trial court's ruling on reasonable promptness wasn't an abuse of discretion. It was 100% correct. The defendant's argument is that we have a conflict simply because we represented the Schmitzes in the underlying case and now represent the plaintiff, which is a fact which we acknowledge, not hiding that fact. They knew that 19 months before filing their motion. The defendants also argue that the unfair informational advantage occurred because we are privy to the Schmitzes' attorney-client communications. But the mere fact that we represented the Schmitzes at any point means that we had access to their privileged information. The law presumes that as their counsel, that the Schmitzes' privileged information from the pre-suit period would have been available to us, even if we didn't represent them until after the lawsuit was filed. So whether we got involved in 2016 or 2017, we would have had access to all of the privileged information from 2016.
Well, but isn't their point that the receiver, if the receiver had different counsel, the receiver wouldn't have access to that privileged information? Or am I misunderstanding their argument?
I think, Your Honor, that could be part of their argument. That interjects whether or not the Schmitzes and the receiver are allowed to share information in this action without it being waived as the third parties under the common interest doctrine. But that just goes to the pending motions to compel information that have been filed by both sides, which of course is not the issue before this court. But just as to before I finish trying to address your question, the point on the waiver issue was that Mr. Noon's deposition didn't reveal anything new. And in our view, that is the threshold dispositive question for this court. So the bottom line is that the trial court considered the defendant's argument and rejected it. And there's no reason for this court to find that was an abuse of discretion.
So let me just follow through with what you said about unfair advantage. Let's assume discovery continues and that they do learn that there was some gathering of information that was confidential between Henderson Franklin and Starnes and JLL that comes to the possession of Swope or someone else, the unfair informational advantage could be resurrected, could it not?
No, Your Honor. I think your question is it's presupposing a definition of unfair informational advantage that isn't defined.
Yeah, I just, what I'm trying to do is get a handle on here, because I think we've identified their fear, which I think is a legitimate fear, is that JLL is going to open up the file of Mr. Boltrick and give it to your firm. I think that is the elephant in the room, is it not?
Well, that is certainly their argument, but that is not
Well-
what an unfair informational advantage means under the case law.
Yeah, you acknowledge, and I think I read a hearing transcript. I mean, and your argument is, yeah, we have access. We're stepping in the shoes of JLL, and JLL is the client and Henderson's the attorney, so we can have all that, right? It's not
That-
privileged as to us.
That is our position, and
That's your position, and I think you got a lot of discovery based on that position. But you're also arguing, yeah, we're getting that, but that's not an unfair informational advantage because we're not using it against a former client. Is that right?
Yes, partially.
Just straighten me out.
Let me back up, just make sure, because we're talking about unfair informational advantage, but it's a term of art that is defined in the case law.
Right.
So an unfair informational advantage comes from learning of an opponent's privileged information. So that doesn't mean that I'm learning of JL Logistics communications. That means that I'm learning of Henderson Franklin's attorney-client communications with their own attorney.
With its own attorney, okay.
Right. So what happens is when a lawyer becomes privy to their opponent's attorney-client communications with their own counsel through the representation of another client in a separate case, then that creates an unfair informational advantage. So the seminal case on this is the court's decision in Fry versus Ironstone Bank from 2011. Factually, it was a little bit complicated. So I actually tried to map out the parties' relationships on page 37 of our answer brief. I don't know if Your Honor has that available to you, but it might be an easy reference. So in that case, it just so happens that Henderson Franklin was the firm getting disqualified. And Henderson Franklin became privy to their opponent Fry's attorney-client communications through their defense of Fry's former attorneys in a second lawsuit, and then used those communications on behalf of another client, the bank, against Fry in the first lawsuit. So what the court recognizes that technically speaking, this conduct didn't violate any bar rules, but it was akin to eavesdropping on Fry's confidential attorney-client communications, which would obviously be improper. And using the second lawsuit to discover Fry's privileged information and then use it against Fry in the first lawsuit. So the general rule is that if there's no violation of a bar rule, then there's no basis for disqualification. But in Fry, what this court recognized was a narrow exception. And because Henderson Franklin learned of its opponent's attorney-client communications, it gained an unfair informational advantage warranting disqualification. So the situation in Fry is nothing like our case. We did not discover the defendant's privileged communications through our representation of the Schmitzes. My firm has always been adversarial to Henderson Franklin. We did not effectively eavesdrop on the defendants in their communications with their own lawyers. To this day, we've not discovered any of the defendant's privileged information, and presumably we will never discover the defendant's privileged information. We're certainly not seeking to compel it. So there's no unfair informational advantage as defined in the case law. And what the defendants are asking you to do is not to follow Fry, but they're asking you to create a new exception, a new rule which says that disqualification is required whenever one side has access to privileged information, which is unavailable to the other side.
Right.
And the defendants say it's not fair that we had access to the Schmitz's privileged information. So just to your point, Judge Kelly, from earlier, we're not seeking to use any of the Schmitz's privileged information in this case. The Schmitzes, through Mr. Noon, are asserting privilege objections, trying to protect it, and then the defendants are trying to compel it. And those are ongoing issues which are not present for the court.
I will confess that the arguments about the informational advantage are not crystal clear to me. But it seems that underlying those arguments is the issue that your firm is getting access to Henderson's attorney-client information from the underlying lawsuit. Yet Henderson, I think, in order to defend itself against the malpractice claim, can't get access to what Swope's involvement and what their communications and strategy was in trying to settle the underlying litigation.
So
It seems like that's really what they want. And they're saying that you're getting something that they can't get the equivalent of.
And those are arguments that they're raising in the trial court below, as there's ongoing litigation over, what specifically is privileged and what isn't, and what everyone's entitled to. What they're arguing in the trial court below is that there's been an ad issue waiver just by our firm bringing this lawsuit. And, I don't want to go too far afield because we're here on a motion to disqualify, and their view of the law is incorrect under a case called Lee versus Progressive from 2005. Where now granted this was a bad faith case, but the rationale is the same, that the motives of the attorney and their counsel, the client and the attorney regarding the timing of settlement offers and the rejection of subsequent settlement offers are not elements necessary to prove a bad faith case. So there was no ad issue waiver. And we're not interjecting any of these issues. Everything's in writing here. The communications were in writing. There's a settlement offer that wasn't accepted. So it's not like the rationale of why a certain settlement offer was made or when it was made. None of that is pertinent to the case from our view. And none of it is a necessary element to prove malpractice on the defense side. But regardless, those are all issues going to a matter not presently before the court. I mean,
no, but I'm looking at this motion to disqualify, and it looks like they're trying everything they can think of.
I would agree with that.
Because, this is an unusual, from their perspective, like, as they have said, it's a veiled assignment. They don't like it. It's an unusual situation. It raises a lot of issues. And this is one of the ways they're attempting to address it. And whether they've actually established a basis for disqualification is the question for us. But why they would do it, I think all this underlies that.
So two points to make in response to that, Your Honor. The first is that they moved to dismiss. It was denied. Obviously, an interlocutory appeal in this vehicle isn't the appropriate venue. If the court ultimately wants to reconsider these issues on summary judgment, I'm sure it'll have the opportunity to do so. The second point is, even if there's something unfair about this, that's not a basis for disqualification under the law. Defendants can't disqualify my firm simply because they think it would be fairer or better for them if another law firm represented the plaintiff. And in the Young case, the Florida Supreme Court said in 2004 that the bar rules provide the standard for determining whether counsel should be disqualified in a given case. Well, we haven't violated any bar rules. And the fact that we have the Schmitz's privileged communications does not violate any bar rules. Rule 4-1.8 prohibits an attorney from using a former client's confidential information to their disadvantage. And what the defendants are accusing us of is using the Schmitz's confidential information to their advantage, saying that it gives plaintiff on behalf of the Schmitz's a strategic advantage in this lawsuit. But even if that were true, there's nothing improper about that. So there's no bar violation and there's no unfair informational advantage as defined by the case law. So there's no basis for disqualification. Certainly no basis to find that the trial court abused its discretion in finding that there was no unfair informational advantage, which was an explicit finding in the trial court's order. The other issue, which I don't know how much time I have left, but the other issue that
you have about 1 minute left.
Okay.
Mr. Steinberg.
We didn't even address the conflict of interest issue. Just very quickly, the trial court properly found that there was no standing. This court's case law is very clear. Just last year in Stopa versus Cannon, that if there's no privity and we don't have a stand in the shoes situation, then they don't have standing to complain about any alleged conflict between the Schmitz's and the plaintiff. And There's no basis for this court to try to expand that rule. And then on the merits, the trial court correctly found there is no conflict. We have a shared interest. The plaintiff has a shared interest with the Schmitzes in the outcome of this action. So there is no conflict. There's no basis for disqualification. So, the defendants had a heavy burden here to demonstrate in the trial court a basis for disqualification. They have a much even heavier burden to demonstrate an abuse of discretion by the trial court in denying their motion for disqualification. And they haven't met that burden. So for those reasons, Your Honors, we respectfully request that this court affirm.
You did it exactly, Mr. Steinberg. Well done within your 1 minute left. Okay. Mr. Drake, I indicated to you, you have 4 minutes for rebuttal. So whenever you're ready, sir, please proceed.
Thank you, Your Honor. I've got a few points I'd like to make. The unfair informational disadvantage, as Judge Kelly was discussing, they are hiding their knowledge, their file, really based on the Schmitz's privilege, the receiver's knowledge. If the receiver has information that it gains through its discovery processes, and we request it, we should be able to get that. That's the way that works. They're hiding it as privilege because they represented the Schmitzes. And if it was other counsel who went and got this documentation and the receiver used that, relied on that information to file his lawsuit, it would be discoverable. Now they say they don't have our privileged information. Judge Kelly, you were talking about that bad faith letter. That was a letter from my clients to the insurance carrier evaluating, discussing the case. Every place else, that's privileged, but in a bad faith case, it's produced. This isn't a bad faith case though. And for instance, their citation to Lee, a bad faith case, doesn't apply. The insurance carrier has an independent obligation to take certain actions and settle when they know or should know in good faith that it's in the best interest of the insured. The question here is whether we fell below the standard of care, not the insurance carrier's standard, but the standard of care is whether we properly negotiated and tried to resolve the case, and they're involved in that. And that, Judge Sleet, is the issue regarding the petition. The petition was filed long after those negotiations were over and the lawsuit was filed and the claim bad faith had occurred. And it did not say anything to suggest that they were involved in those months preceding it. We're in this catch-22 situation. Is the petition sufficient to argue that they should be disqualified? Well, Mr. Steinberg tells you today, no, it's not, and we didn't present any other evidence. Well, I'm here to tell you that it would have been a much harder argument to make and not factually supportable without Mr. Noon's testimony that established that the Swope firm was involved from day one, that established the Swope firm was involved in interviewing and retaining the receiver, that established that there was no termination of the relationship, even though Swope firm took that position in unsworn discovery responses. There were facts that we relied on in our motion. It wasn't, we just established, threw that in at the end or in a reply brief. We used that information in our motion to disqualify, and we rightfully depend on that in this case. I've talked about, well, I guess it's the simple thing is, yes, Judge Kelly, the fact is that this all comes from the receivership used as a vehicle to bring a legal malpractice claim. But the fact that they use the Schmitzes are the real parties in interest here, and they're writing this case with their own counsel as the receiver's counsel, which does give the receiver, i.e. the Schmitzes, an unfair informational advantage. It does. It also gives an unfair tactical advantage because they can assert a privilege that my client doesn't get to assert because the receiver holds my privilege. This is a unique case, Your Honors. You will not find any case reported in Florida on this with this set of facts because this is a new area of practice for the plaintiff's bar.
And it probably won't be the last time we see it.
I would agree to that, Your Honor.
All right. And
I'd
with
ask,
that- And with that, Mr. Drake, you have exhausted your rebuttal time. And I want to thank you both, gentlemen. You really did a fine job articulating each of your respective